This is an initiative between WorkSafe BC and the BC Forest Safety Council to have quarterly webinars on various different topics that we have going, or timely topics that are things that are happening sort of in the now. Today we have Mike Tasker, and we have Rodney Scholar from WorkSafe BC. Start off with Mike Tasker. He's an occupational health and safety officer. Extensive experience in occupational health and safety with WorkSafe BC, most recently with their risk analysis unit. He's also spent a lot of time in the development of various different regulations, with combustible dust being one of them, which is the topic for today. And so Mike brings sort of an inside look at sort of the history of the development of the combustible dust regulation, or the proposed combustible dust regulation changes that are in the sort of final stages. We also have Rodney Scholar, a senior policy and legal advisor from WorkSafe BC, who was also very active in the development of the combustible dust proposed regulations. Both of them bring a wealth of knowledge, not only in the development of the new regulations and why they are happening the way they are, but also in the process that takes place to get something as something as vast as a combustible dust regulation that covers all industries, from initial sort of development to a final regulation. So before I hand it over to Mike and Rodney, I just want to say the BC Forest Safety Council has a lot of resources available for people. They're located in the chat function, where you can sort of click on that to register for crew talks, safety alerts. Also, if you send an email to Tammy, who's on the line here, she can also sign you up to have access to the emails for these various different voices episodes that we're doing going forward this year. Just to give you an idea, we do have some tentative topics for the rest of the episodes. Mobile equipment pedestrian interface might be coming up sooner rather than later. We might be having one on the first aid regulations, return to work, or ergonomics. We haven't really set in stone the rest of the episode yet, because we're really trying to get a feel as to what's the next step, and which is the one that's going to be most beneficial for participants. So with that, I'd like to turn it over to Mike and Rodney. So welcome, guys, and thank you very much for doing the presentation. We appreciate it.
Thanks, Bill. I appreciate the invitation. And there's one thing that I'm really confident at, that is, since this is the first episode, at the conclusion of today, we will have been your best episode. So I think there's a certain level of comfort in that. Okay. I'm going to go off camera just while I'm presenting, and I'm going to share my screen really quickly here. And hopefully you can all see that.
Yeah, that looks good, Mike.
Okay, thanks, Rodney. So the title of the presentation you can see today is, so you think you have a combustible dust, what's next? And we sort of chose this because of the new regulation and the breadth of the scope that is being brought in. Is certainly looking back, since the two monumental events that happened in 2012 in British Columbia, there's been a lot of focus on wood dust, but we know that wood dust is not the only combustible dust, and we wanted to make sure that we conveyed this notion that combustible dust can take many forms, and we're going to have a discussion about what the new regulation is intended to do in regarding that broader spectrum. Rodney, I think you had a couple of opening comments.
And so we'll touch on a number of different topics, and that will give you a bit of a historical background about combustible dust in British Columbia. We'll explain why these new proposed regulations are being developed by WorkSafe BC. We'll go over how exactly new or amended regulations get introduced in British Columbia. We'll go over a general framework from a high level of the key elements that are incorporated into these new proposed combustible dust regulations. We'll update you on the current status of this regulatory project around combustible dust regulations, and then we'll speak about how the new regulation will be supported once it eventually does come into effect. Feel free to ask questions during the presentation, but it might be perhaps a little more effective if we hold the questions till the end. I think between Mike and I, we'll have enough time still at the end of the presentation where we can field some questions from the audience here. So Mike, I'll pass it back to you there.
Thanks, Rodney. So often, Rodney and I have made this presentation now a couple of previous times, and we like to sort of shape the context of what we're talking about, like I said, so that it's not limited to just this concept of wood dust. Now, I know being this is a webinar from BC Forest Safety Council, wood dust is of primary concern, but there are other dusts, and of course, this was a historical example from 2008 of a massive explosion at the Imperial Sugar refinery in Georgia. You can just see the level of damage that can occur when a combustible dust ignites and creates that massive amount of pressure and flame front that occurs. Now, in British Columbia, we're not immune to it either. Of course, in 2012, we had 2 mill explosions occur. These are particularly personal for me. I was called to respond to both of these events. The photo on the left is the Babine sawmill site that occurred in January of 2012. And just to sort of describe for you what that experience was like, to kind of put a human story to it, this happened late at night. We'd gone through several days where the temperature never rose above minus 20, 22. And about 10 o'clock one night, my phone rang, and it was a call saying basically this message: Mike, we've had a mill explode. We need you and other officers to deploy immediately. What we know so far is we've had, it's a mass casualty event. We've got about 22 people seriously injured and 5 still missing. And so myself and 3 other officers deployed to this site in the middle of the night. It was the driving, which is normally about a 2-hour drive to get to this mill site, actually took us 4 hours because of the road conditions, because it was a whiteout snowstorm. But we knew that there was no turning back. We had to respond. This was also a situation, this was my first experience with what's called a code orange. And if you've never experienced a code orange, it's a situation where a health authority announces that the local hospitals are full, cannot take any more patients. And so as a result of that, there was airlifts to Vancouver and to Edmonton to try and deal with the mass number of casualties that responded to this event. Also, to put a bit of a human spin on this, some of the issues that they were dealing with, of course, being that it was so cold, you've got workers that are milling about and being treated. Some of the workers were wearing high visibility vests, and the flame front that occurred from the ignition of the dust actually caused the high visibility vests to stick to their skin and burn through the clothing. So they were having to be stripped naked in the mill yard to try and deal with the burns that were occurring. That's the nature and scope of an incident like this. The images on the right are the images from the Lakeland Mills explosion that occurred in April of 2012. Again, it was late evening, and my wife and I are getting ready to go to bed, and we hear and feel up against the side of the house that sort of whoomph, that wind slamming up against the side of the house. And my wife actually made the comment, "Oh, storm's brewing." And that's kind of what we thought until a few hours later when the phone rang again and we got a very similar phone call. That whoomph was in fact the pressure wave that blew from the explosion. I live about 8 kilometers away from the mill site, and that pressure wave was significant enough so that I felt it slam up against the side of the house. What we thought was a windstorm was in fact the mill exploding in the downtown area of Prince George. So these are two situations that are, as I mentioned, very personal to me, and to anyone that works in the and lives in the vicinity in the Prince George, Burns Lake areas, because this not only changed this company or these companies, but changed people's lives forever in a very profound way, myself included. And it has sort of initiated a decade-long sort of work, passion project, if you will, in trying to deal with the hazards associated with combustible dust, of which the new draft regulation is just one part of that. So what's the current state of our regulatory requirements? Well, we kind of put them into two buckets. There is a health hazard associated with dust, whether it be combustible or not. And that's dealt with in Part 5 of the Occupational Health and Safety Regulation. For the purposes of this project, for combustible dust, we didn't deal with the health impacts. There's other groups that are dealing with the health hazards. The scope of our work in developing new regulations that pertain to combustible dust deals exclusively with the fire and explosion hazard. So there's nothing new on the front in regards to respiratory hazard or anything associated with the health impacts of breathing in the dust, whether it be combustible or not. Currently, and as a product of what we did immediately after the mill explosions, is we developed some what we refer to as enforceable policies, and you see them listed there, P2-21, 1, 2, and 3. And that assigns duties, general duties to employers, workers, and supervisors that work in workplaces that contain combustible dust. This was done as a way to quickly address some of the hazards and the hazard controls that we needed to see, understanding that drafting regulation is a very time-consuming process, but we needed to do something quickly that could start to lower the risk. As a result of those explosions as well, we had specialized teams trained up to do combustible dust inspections, and many of you will remember if we visited your site, I was part of that team as well, and combustible wood dust at least became a very high focus for us at WorkSafe BC. And Rodney's now going to talk a little bit about sort of the process we follow in writing new regulation. It's not a really quick process, and you'll kind of pick up on why and why that's important.
Thanks, Mike. So first, how did we arrive here talking about these new proposed dust regulations, and why has WorkSafe put work into this? One reason certainly being those two incidents that Mike has referred to back in 2012 between Babine and Lakeland. The other reasons for why improvements need to be made on this topic are that the existing regulation has very limited language around combustible dust and managing the risks associated with them. And lastly, after the introduction of those three policies that Mike referred to, we seek to have a regulation that will ultimately replace those policies, because those policies are very focused only on wood dust mitigation. So that's sort of the reasoning behind why we got into this substantially large project. I'll speak now about the legislative hierarchy, just at a high level, to give you an understanding of where regulations fit into the legal scheme. The legislative hierarchy that that the regulations fall under sort of have 5 components to them. The top of the hierarchy is the Workers' Compensation Act. That's what sets out the laws around health and safety in the province. Underneath the act are regulations, which go into more detail about specific topics or areas. And the regulation and the act together, these are what are legally binding in the province. They are the law in essence. And further below the act and the regulation are more supporting materials that underlie the foundation that's in the act and the regulation. And those are found in policies and guidelines. The policies, they help and assist in the interpretation and the purpose behind the particular regulation or a section in the act. And then guidelines further below are more, I'll say, informal of sorts compared to policies and the regulation. And the guidelines, they act as additional guidance information for the enforcement and the compliance of the laws that are set out in the act and the regulation. So that's a picture of the legislative hierarchy that exists. Now, within the Workers' Compensation Act, WorkSafe BC has certain authorities and certain responsibilities in regards to developing regulations. There's a section 111, which grants WorkSafe the authority to make regulations in the province. There's also a requirement for WorkSafe to regularly review regulations and determine what areas need further development or amendment. There's a requirement, there's requirements under section 113 around what needs to be done before introducing new regulation. And there are timing requirements under 114 timing requirements for when a regulation ultimately does come into force. Now, BC is a little unique in having these type of authorities. Not all jurisdictions have the regulating body be responsible for the development of regulations. Often in most other jurisdictions in Canada and states in the US, it's the government and a government body or ministry that would have that regulation making powers. So it's an authority that is somewhat unique in British Columbia to WorkSafe BC, and it's one that we treat quite carefully and preciously. Now, moving on to the process itself, it's a very involved process for WorkSafe to develop new regulation. And the next couple of slides will set out the multiple stages that go into this process. As I said, it's quite involved. There's about 10 steps basically, but firstly, there's a regulatory agenda which gets prepared by WorkSafe BC. This agenda is presented to our board of directors and ultimately gets approved, and it will from that agenda will be produced what we call a work plan. The work plan sets out the projects that WorkSafe BC is currently working on from a regulatory standpoint. The department, so in my role as a senior legal and policy advisor, I'm basically a project manager and I lead projects with teams of subject matter experts on working on specific projects. And it's our department, the Policy, Regulation, and Research Department, that oversees these regulatory developments. Now, the projects that come onto our work plan, they come from a number of different directions or from different stakeholders. They can be requests made from our very own board of directors at WorkSafe. They can be requests that are presented to my department from other internal divisions within WorkSafe, such as our engineering division, our prevention division, or others. The requests come in externally from external stakeholders, whether they be employers or employee representatives. And we get requests from the provincial government directly, and also some coming from the BC Coroner's office through inquests and inquiries that they've been involved in. So once the work plan gets approved, the project working groups are then set up, and my department gets involvement from subject area experts internally within WorkSafe from other divisions, such as our prevention field services, which Mike's a part of, our engineering group, our practices and quality department, and our continuing education services department, whose name has now been changed, and I can't keep track of all the new names. So we work together to analyze the issues that are involved in a particular regulatory project. The working group, does research, analyzes the issues, and develops key policy objectives that we want incorporated into a new regulation. The actual drafting of any new regulation is done formally by a team of lawyers and drafters called Legislative Council, who work out of Victoria and are part of the Ministry of the Attorney General. So it's Legislative Council who come up with the formal draft language that WorkSafe will ultimately go out to stakeholders for. Now, what's crucial about this very involved process that I want to raise with all of you today is that it's a very consultative process. There are multiple opportunities for where WorkSafe goes out to stakeholders in industry seeking their input at different phases of the project. And it's one that, as I said, very consultative and very much more involved than I believe other jurisdictions around Canada. And the first consultative stage is at the bottom of this page, called the pre-consultation. That's the first consultation. This is a session where a limited number of external stakeholders are asked to review what has been drafted up until that point, to give the WorkSafe BC and our project team an idea of, are we going down the right path here with this project, or are we missing certain issues that need to be addressed in the new regulation? So for the DUST project, that pre-consultation happened about 1.5 years, 2 years ago, back in 2023. And we reviewed it, all the feedback, and moved on to the next stage, which takes us to the next slide. So after the pre-consultation, the working group on the project reviews all the feedback that we receive. We make necessary changes and revisions to the proposed wording of the regulation, and Legislative Council produces a new updated draft version. WorkSafe BC then takes that draft out to the second step in the consultative sessions, which is a public consultation. The public consultation is the stage where the draft is shared for the first time to the entire public and to all stakeholders. And it's posted on our website, and stakeholders are invited to give written submissions with feedback on their thoughts about the proposed regulation. Our public consultation for the DUST project occurred last summer and concluded in May, and we received a fair amount of feedback from stakeholders, which was very helpful. Similar to earlier in the process, after public consultation, again, our team reviews all the feedback. We make further revisions, and we work with Legislative Council on further improving the wording and the draft regulation. And then we arrive at the final of the 3 consultative sessions, which is a public hearing. And the public hearing is the final of these consultative sessions. And they used to be held in person, but they're now being held virtually by WorkSafe BC. And stakeholders are invited to attend a live session and give feedback orally at the meeting, at the physically held meeting. If they are unable to attend a public hearing, stakeholders can still submit feedback in writing to WorkSafe BC. For the dust project, and I'll be talking about it later, we are now arriving at the public hearing stage for that particular project. After the public hearing, our anticipation or expectation is that there are only minor revisions, if any, that are needed to the new proposed regulations. At that stage, our department, my PRRD department, we go to our board of directors at WorkSafe and we recommend that they approve the new regulation. Based on once the board of directors gives their approval, there's a legal process in terms of introducing the new regulation. There's a notification process. There's a notification process that WorkSafe BC must give public notice within the province of the introduction of the new regulation, and the new regulation is formally deposited with the Office of the Registrar's Office in Victoria. 90 days after, a minimum of 90 days after the formal deposit of that regulation, a regulation will come into force in the province. So that gives you a real high-level view of the process to introduce new regulation or make an amendment to regulation. It is very involved, and it's very involved primarily because of the multiple consultative sessions that we go through to get feedback and get buy-in and learn from stakeholders who are being impacted by these projects. Mike, I'll pass it over to you.
Thanks, and thanks, Rodney, for that that explanation about the process. Sometimes I get questioned, why does it take so long to write new regulation? Well, it's largely because, and it certainly proved itself in regards to this subject matter, it's, can be very complex, and we write regulations for a wide range of work sites, from the very simple to the very complex, from the very large to the very small, and trying to get that right and offering sufficient consultation to all the affected stakeholders certainly does make this a very time-consuming process, but I think it's an important process that we follow. So what's covered by the proposed regulation? Just a few key points. The regulation now expands the consideration of any dust that is either handled or generated at the workplace, potentially comes under the regulatory force of the regulation. And when we're talking about, say, for the purposes of generated, we're talking about processes that may grind or chip or in some other way produce a dust that could be combustible. And in fact, it also expands to systems that may handle the dust. That would include storage vessels like bins and hoppers and silos, and also include things like dust collection systems and pneumatic conveyance systems. So any dust that's handled or generated in the workplace at least begins down the road of being regulated by this regulation. And as you can see there, it's much broader than what we've been focused on for the last decade, which is wood dust. It also expands into other areas such as metal dust, agricultural dust, plastic dust, including industries that haven't had a large focus in relation to combustible dust. Places like bakeries and craft breweries and whatnot that deal with grain dusts and flours and things like that, and even so far as places that generate or handle byproducts such as lint from large commercial laundries in hospitals and hotels and whatnot, potentially could be covered by this regulation. However, what is excluded from the regulation is dust that's in a sealed commercial packaging. So the 5-pound bag of sugar at your local supermarket is not covered by this regulation. However, if take that same product and now it's trucked in into a large commercial enterprise and it's being dumped into a silo, then that would bring it into effect under the regulation. I want to make an important note here, as Rodney has mentioned. We're still in the consultation process, albeit nearing the end. of the consultation process, but we always like to put in a bit of a caveat that until the final version of the regulation has been signed off by our board of directors and approved in Victoria, the regulation is still proposed and it still remains in draft format. It is subject to change. At this late state, I don't know if we're anticipating a lot of change coming, but we always need to be open for change that may be brought forward and our ability to adapt to that change as recommended from our stakeholders. So what's really noteworthy about about the proposed regulation? We tried really hard, and this actually proved to be quite tricky, to find an appropriate balance between performance-based regulation and prescriptive-based regulation. We know in different industries and different sizes of companies, there's often a preference between performance-based regulation. That's regulation that's often described as being outcome-based. We say you must achieve this outcome and leave the how you do that to each individual employer. But we also have a lot of employers that prefer a prescriptive-based regulation. That is, just tell us how to do it and don't leave it to us to figure out, because we don't have either the resources, the people, or the expertise to do that. We often refer to this balance as trying to achieve a level of scalability. And that's something that we, really invested a lot of effort into making this regulation as scalable as we can, as I said, because it deals with employers and processes that are from very simple to very complex and from very small to very large. So it's definitely not a one-size-fits-all type of regulatory format. And we went back and forth for many months trying to make sure we got that balance right. And as I've mentioned, it greatly expands the focus on combustible dust to not just being wood dust. There's a whole lot of other industries out there that this may be the first conversation they have with a WorkSafe officer in regards to the products in their workplace and whether or not they are combustible dust. And it expands on the expectations for those employers to be knowledgeable about their dust and to take steps to manage any hazards that arise from it. And in doing so, the regulation expands in two key areas. That is conducting a risk assessment for your dust. And we'll talk a little bit more in detail about what that risk assessment looks like in just a little bit. But once it's been determined that the dust that you have in your workplace is in fact combustible, then there's a requirement to manage that dust or the hazards of that dust through a combustible dust management program. To date, under the existing legislation and those policies that both myself and Rodney talked about, the only industries that were required to do a combustible dust risk assessment and have a CD management program explicitly were 8 wood products manufacturing classification units, or industry groups, if you will, industry sectors. And those requirements are going to be much more broadly implemented now with the new proposed regulation. The next thing that I want to sort of touch on, and we're going to dig into it a little bit more in detail, is something that we call our roadmap. And these are sort of the 4 key areas of navigating through the regulation. These are the general provisions underlying everything that that is covered in the regulatory framework of this new set of regulations. There is an assumption clause, and we'll talk a little bit about that. As I mentioned briefly, there's also a requirement for a much more detailed risk assessment for your individual workplace and any dust that may be generated or handled in your workplace. And once it's determined that, in fact, you do have a combustible dust, then the development of a combustible dust management program. And in some cases, depending on the type of equipment that you have in your workplace or the type of processes that exist there, we've also specifically listed some risk controls that must be in place. So if you have X piece of equipment, here are a few of the things that you have to have in place, at least as a minimum. It's not all-encompassing, it's not an exhaustive list, but it establishes some minimum requirements for specific risk controls based on individual processes and machinery that might exist. So what do we mean by an assumption clause? Well, basically the assumption clause is if your workplace handles or generates a dust you must assume that it's ignitable and deflagrable, meaning it's a combustible dust. And the key underscore here is that the workplace handles or generates the dust. We're not talking about the dust that may accumulate on a windowsill in an office somewhere. It's actually dust that is either handled or generated at the workplace as part of the workplace processes. So once it's been identified that you have a dust, your next step, you have to assume it's a combustible dust, unless you do one of two things. You actually have the combustible dust, a representative sampling of the dust, tested, and we prescribe the testing methodology that has to be followed by a laboratory in order to do that. Or you rely on objective test data that has been published by a recognized organization that is derived using the same testing method that we prescribe. So you may not need to foot the bill to do individual testing for your workplace, provided that a reputable organization, and there are organizations, one being the Justice Combustible Dust database that is published in Europe, that lists quite a large number of dusts and the level of combustibility and a lot of the technical information behind that. Otherwise, it's you assume it and treat it as though it's combustible dust, or prove that it's not using one of these two methodologies. The risk assessment component. So once you've determined or assumed that you have a combustible dust, then you must engage in a risk assessment. And within the regulation, we actually lay out the type of information and factors that you must consider in conducting a risk assessment. And the risk assessment must be done by the employer in consultation with a qualified person. This term qualified and qualified person often can get a little bit contentious. And Rodney's going to talk a little bit more about our use of the word qualified within the regulation. But we rely on the definition of qualified as it's depicted in section 1.1 of our regulation as it currently exists now. We don't require a specialized accreditation as a dust expert or anything like that. It's really dependent on the nature of the skill set for the person that's undertaking a particular task. And as I said, Rodney's going to dig into that in just a little bit more. The important aspects is the responsibility to conduct the risk assessment rests with the employer. And as part of that, the employer has to consult with a qualified person or persons in conducting that assessment. So once you've completed the assessment, that's essentially a process of identifying the hazards, assessing the severity of those hazards, the likelihood of those hazards actually causing an ignition. So the next step in the process is to develop a combustible dust management program. And the intent behind the management program is to implement the controls needed to manage the hazards and risks that were identified through the risk assessment process. This too needs to be developed under consultation with a qualified person. And this is really the how-to book. So for example, if the risk assessment determines that you have a combustible dust and that as part of a control measure for that combustible dust, you need to engage in regular cleanup of your workplace. Well, what the management program would do would provide procedures and guidance as to what areas need to be cleaned up, how it's to be cleaned up, what the methodologies are for cleaning up, what would happen if there was a process upset and you now have an unexpected release of a combustible dust, and basically all those sort of finer details on how we're going to manage the hazards and risks associated with the combustible dust at our workplace. Once again, within the regulation, we outline the elements of a combustible dust management program and basically provide guidance on the types of things that should be contained within the program, and understanding that each workplace is going to be a little bit different, a little bit unique, and essentially the outcome that is required is that the program lends itself to effectively managing the risk at that individual workplace. So as I mentioned, the issue around a qualified person sometimes stirs up a lot of discussion, and I'll turn it over to Rodney and he can sort of talk a little bit about our thinking behind the use of that term.
Thanks, Mike. So the qualified person plays an integral role throughout the draft regulations. And by that, the regulations set out a number of different requirements that an employer will have to undertake. And the qualified person will be involved in a large number of those responsibilities and requirements. And when it comes to who is qualified in what particular circumstance, it's one of those situations where, one specialized definition for the dust regulations as a whole would not fit all the holes in the puzzle, and would not fit all the requirements that are set out in the dust regulation. So this plays very much into that issue of scalability that Mike touched on earlier as well. At the end of the day, our project team has determined that the proposed dust regulations will fall back on and rely on the current definition of what it means to be qualified, set out in Part 1 of our current regulation. And that definition is on the screen there for all of you to see, but to be qualified, a person is one who is knowledgeable of the work and knowledgeable of the hazards involved with that work and knowledgeable of the means to control those hazards. And they're knowledgeable by way of education, training, experience, or any combination thereof. It's a very general definition, but it's one that when you break it down and look at it, it fits all the pieces that we need it to fit for the purpose of this regulation. Whether the responsibility or the requirement deal with setting up work procedures to mitigate dust risk at a workplace, or the responsibilities involved in establishing work procedures, cleanup schedules, let's say, to manage quantities of dust, or whether the requirement is to design and install a combustible dust collection system from an equipment standpoint. There are varying degrees of knowledge depending on the task involved. And this definition allows a proportionality to be in play and allows for a scalability where the degree of knowledge is on a moving scale, and the degree of knowledge changes depending on what the task or the requirement being called for in a particular provision in the reg is. So that's where why the project team has landed on applying the current definition as is, because we're of the view that it does what it needs to do for the purpose of this reg, and to try and create any type of more specialized definition for what is qualified doesn't serve any benefit, and complicates the regulation even further. To the point of the qualified person, we use the term person, but that person doesn't have to be one single individual who is your expert in everything across the board at the workplace. It can be a single person, but it can also be a team of people who bring knowledge about certain areas of how to mitigate dust, and they bring knowledge and expertise about certain requirements that an employer needs to comply with in the reg. So that gives you, I hope, some understanding about where this project and where the proposed regulations are directed with, in terms of having this qualified person involved in the several stages of requirements that are set out in the regulation. Speaking more about the draft regulations, they Mike was talking about a roadmap and the framework that they're set up in. The framework that they're drafted in currently seeks to set out specific requirements for an employer based on certain, I'll say, topics. One being the type of dust, in particular, whether it's a metal dust or non-metal dust. That's the main distinction within these regs. Other specific requirements around workplace circumstances. Those could be, identifying sources of ignition, the means or manner in which dust is being stored or produced, and identifying sources of dust at the workplace. When it comes to the risk assessment requirements that are set out in the draft, the risk assessment, in essence, it basically targets and is drafted in a way that is aimed at the 5 explosion pentagon factors. So in large part, our risk assessment requirements in this draft target, A, the type and amount of fuel that's present at a particular workplace, the amount of fuel, the dust. 2, the sources of ignition that might exist and be present at that workplace. 3, the degree and potential for confinement of that dust at a particular workplace. 4thly, the possibility of the dust being dispersed or suspended in the air at that employer's worksite. And lastly, and to a much lesser extent, the presence of oxygen, which is required for a fire or an explosion. And in most cases, oxygen will be present at workplaces. It's only in rare circumstances where it's not. But the explosion pentagon principles are what guided this draft regulation in terms of the risk assessment criteria and the risk control measure requirements that are set out in the draft as well. I'll pass it back to you, Mike, to continue.
Thanks, Rodney. So I suspect for many of you that are on this call, again, being from wood products manufacturing industries, having an officer knock on your door and say, I'm here to do a combustible dust inspection is not necessarily something that's new. For some of you, it might be. And so I wanted to spend just a minute talking about, what a typical combustible dust inspection looks like, whether it's done currently under the regulation now or what will be done once the regulation, the new proposed regulation goes into effect. And typically what occurs when an officer shows up, certainly this is my experience. I've done, I don't know, a few hundred combustible dust inspections over the years. And they all kind of follow the same type of format as part of it. And this isn't necessarily in sequence, but as part of the CD inspection, we're going to look at some of the available documentation. We're going to want to take a look at the risk assessment that was done. Of course, to date, there's only a few industries that are required to do a risk assessment. But of course, as that expands with the new regulation, that'll comprise a fairly typical part of any combustible dust inspection in any workplace where there is dust present. We're also looking at the CD management program to see how the employer is planning on dealing and managing with the hazards of the dust. And of course, we do a bit of a comparative analysis between what was identified in the risk assessment and the controls that for those hazards that are contained within the program. We also do a comparative analysis between what we are told should be in place from the program to what we actually hear and see when we do a site tour. Site tour is always done for a combustible dust inspection, and we're looking to see whether or not the combustible dust management program is actually active and alive in that particular workplace. It's one thing to have a program that says we're going to do X, Y, and Z, but when we get onto the facility floor and we find out that it's LMN, we seek to understand why that difference and what needs to be done to get those two realities aligned. And doing the site tour, we're going to talk to people. We're going to talk to workers and supervisors about what they know about the hazards of combustible dust and what the expectations are that the employer has placed on them to manage those hazards. So in doing so, we tap a little bit into the education and training of these key individuals that play a role in managing combustible dust at the workplace. Again, where we see gaps, then we seek to understand with the employer as to why those gaps might be there. Perhaps it's time for a refresher training or some other measure to be undertaken to bring the management of combustible dust up to a higher level. And Rodney, where are we in the process here?
Yeah, so it's been a very lengthy process of multiple years to get us to this stage because of the scope and breadth of the application of these regulations and the complexity involved in them. So I'd walked you through that very involved process earlier in the presentation, and now we are getting to the final stage of the consultative sessions, that being a public hearing. So the last consultative stage was the public consultation. That's where stakeholders provided us with written feedback, and we did receive a large amount of feedback last summer. We spent a number of months reviewing it, going back, reviewing the language and the sections that had been drafted. The working group then worked with Legislative Council on making more revisions to the draft, and we've arrived at our updated draft, which has just been posted. It was early last week where notification went out, and if any of you are registered for our electronic notices for these types of projects, you would have received an email. But notice has gone out, and the public hearing is now set for May 14th, in a month from now. Again, this is a virtual hearing. The public hearing allows the opportunity for any stakeholder to come and speak directly to a panel of senior executives or senior managers with WorkSafe BC who are overseeing the project at a higher level. And it allows the stakeholders the opportunity to speak and give their feedback orally on the topic and on the draft. You can register to speak in advance. You can register and sign up to speak at the public hearing, and you'll be sent information about the timing and the order of presentation for stakeholders. You'll receive information from our offices. There's a website here on the presentation slide that sends you to the location where the draft of the regulations is, and all the information needed to register for the public hearing is. I will share this website with Bill after this meeting so he can distribute to the larger group here this morning. But again, May 14th is the date that's now set for the hearing. As I said earlier, WorkSafe BC is required under the Workers' Compensation Act to have at least one public hearing. There are projects that we have undertaken from a regulatory standpoint that sometimes involve more than one public hearing because based on the scope and degree of feedback we receive at the first public hearing, there becomes a need to make substantial changes to the draft. And WorkSafe might have to go back again for another public hearing. But the requirement under the Act is for us to hold one public hearing at a minimum. So if things go smoothly and there aren't any major substantial revisions to be made, my department, we will then move and proceed to our board of directors to seek their approval of the proposed regulation, as I mentioned earlier. And it then becomes formally deposited, and 90 days after that deposit, at a minimum 90 days after that deposit, the new regulations would come into effect. So we're at the final consultative stage now, the public hearing, which will be held next month, and we're very much looking forward to hearing more feedback from stakeholders out in different industries, the wood sector certainly, but other industries as well. We're hoping to hear more from. And Mike, I think that concludes where we're at, Mike, and you can take it from here.
Thanks, Rodney. So We recognize that the regulation is only one part of communicating expectations, and often it's not the best in describing in detail what the expectations are in managing risk. So we kind of refer to this as a three-legged milking stool. So we've been hard at work for the last going on 4 years, writing the regulation, seeking consultation on the regulation. What's also been going on in the background is we've been hard at work writing a companion manual to the regulation that goes into much more detail and can communicate much more clearly some of the concepts of the hazards around combustible dust and some of the control measures and how they work and how they should be designed and things like that. So it's really meant to support and supplement the language that's in the regulation. Of course, when you write regulation, it's written in lawyer language. It's, you know, legislatively enforceable, but not necessarily really helpful, especially to small or medium-sized business that is needing to interpret this for themselves in their individual workplace. So we've felt that developing a companion manual, similar to other manuals that we have from WorkSafe on subjects like safeguarding and lockout and things like that, would be an essential companion to the regulation. In addition to that, we're also working in the background, developing training curriculum for our officers on not only to enhance their knowledge and understanding of combustible dust, but also the expectations of the regulation, because clearly, you know, your local WorkSafe officer is a resource for you to tap into. And we want to make sure those officers are, you know, up to the task, that they are aware of some of the detailed information, and also how to go about enforcing the regulation to assist employers and workers in managing that risk in their workplace. So all these three fronts are all working in simultaneous. It's a little bit like playing three-dimensional chess, because the regulation does change from time to time, which means we have to make updates on those other two aspects. But by the time the regulation actually goes live, these other two legs of the milking stool will be ready to go. So hopefully we can release everything simultaneously. Also, draw your attention to our website. There is a tremendous amount of information on worksafebc.com about combustible dust, albeit to this point, most of it relates to wood dust, but not entirely. So if you have questions, and certainly if you want to take a look at the latest version of the proposed regulation, the one that's out for public hearing, that's where you can connect with that information as well. We also recognize that there may be a need, or there is a need for the establishment of some guidelines. Guidelines serve to interpret some of the provisions of the regulation from a legal perspective. There's not a lot. We try to write regulation in such a way that they don't need other explanatory guidelines or policies, but often that's kind of an impossibility. There's usually a need for just a few clarifying guidelines to help stakeholders interpret what the regulation requires. And in part, we're also doing outreach campaigns with industry associations, BC Forest Safety Council being just one, Manufacturing Safety Alliance of BC being another, and talking to them about the draft regulation, what's being proposed, talking to them about making sure that they are adequately prepared to provide the support to their members. And I know that's a key aspect from Bill and from Tammy from the council, to make sure that they're able to answer the questions, meet the needs of their member stakeholders. And we've been trying to keep them up to speed as much as we can as this regulation has proceeded over the last few years. That's our presentation, and be interested to see what any questions that you might have for us at this point.
Thanks a lot, Mike and Rodney. It was great, the information you provided. It's kind of a behind the scenes sort of look at how this all played out. Before we jump into the few questions that we do have, because we don't have much time left, is you know, my personal thanks for the hard work that's been going into all of the development of the regulations, and also including us in the pre-consultation. And the fact that you're working hard to get that companion manual out as quickly as possible. I believe means a lot for the people in the industries that I support. So thanks for doing that. We'll jump into a few questions here. There was a question regarding if there's a review in place by the BC Fire Service Act or the BC Fire Code to ensure consistency of language and approach. I don't know of anything happening there.
So certainly in
go
the
ahead, Mike.
development of the regulation, we look to see, we do what's called a jurisdictional scan and a legislative scan to see what other codes and standards apply. But of course, we don't have jurisdiction to enforce or update those other codes. We use them to inform us, and where we can, we certainly are aware if there's a potential for conflict, and we work really hard to try and remove any potential conflict between our regulation and any other code or standard. Rodney, did you want to add to that?
Yeah, and also at the pre-consultation, BC Professional Forest Fires Association, the Fire Chiefs Association, and the Office of the Fire Commissioner were all notified and invited to the pre-consult. Most of them attended. So those branches in fire services are aware and have seen the drafts to our understanding. So there's been some involvement and communication between WorkSafe and those fire service personnel.
Thanks. Now we're going to be going over, so as long as it's okay with everybody, just go over a few minutes for some of the other questions. I'll go to the ones that were submitted in the chat first. Is a requirement for an annual review of the assessment and program that needs to be conducted by a qualified person also. So I'm assuming that they're asking, does a qualified person have to get involved in the annual review of the program and the assessments?
So essentially, the program needs to reflect the current state of affairs in the workplace. Conducting an update if the conditions change is a regulated aspect, and that would be also that new risk assessment if the conditions change would involve a qualified person as well. Rodney, do you want to add?
And there is an annual requirement.
Yeah.
Despite there maybe not being anything sort of substantial changing at your work site, there is still an annual requirement to review the program.
Thanks. The last question here is, would WorkSafe prosecute a person that conducted one of those assessments that they deemed inadequate, therefore deeming the person completing the assessment not competent?
Wow, that's a bit of a loaded question. So what I will say to that is, the expectation is that each employer that engages with a qualified person, whether they be internally within their organization or hiring an external consultant, needs to do their due diligence to ensure that the person is qualified for the specific task that they're undertaking. As Rodney has said, the person who may be involved in developing your cleanup schedule for your combustible dust would likely be somebody that's very different than the person who's designing your sprinkler system or your combustible dust, your dust collection system. So it's really a matter for the employer to, as I said, to do their due diligence to make sure that person is sufficiently qualified in the work that they're being asked to do. That includes doing things like reviewing resumes, reviewing and perhaps talking to previous clients to assess the quality of the work. In basically the way WorkSafe deals with this is we look at the quality of the product that was produced in determining whether or not it's appropriate, and we use that to inform ourselves as to whether that person was in fact qualified to do the work. The whole issue of whether an individual would be prosecuted, that's a pretty extreme situation. There would need to be some fairly extreme problems that have arisen, knowingly and wantingly, terms like that, and things like that, before we engage in any sort of prosecution. It is a possibility that an officer, and one of the aspects of the training for the officers would be to teach them how to evaluate the quality of a risk assessment, if you will, or a combustible dust program. And where it falls short, obviously it's at the employer's discretion to try and help that employer fill the gaps, and to explain to them where maybe there's some deficiencies and to work through them. But as I said, it would be a very extreme circumstance where we'd even consider a prosecution on that.
Thanks, Mike. Now, there's two more questions. If you guys are okay to take those, those will be the last two we take.
Sure.
So the first one is there going to be a prescriptive requirement on dust management, or each employer decides on their approach in satisfying regulations?
The draft reg allows flexibility for an employer to determine what path they seek to take in order to adequately manage the risks of their dust. The prescriptive requirement lies in having a dust management program, but what the contents of that program and the how part of it is very, because of that scalability issue, there's very much flexibility and discretion to a degree with employers on how they go about setting up the specifics of that program. So the prescriptive part is on the having the program. What's part of that program very much lies in the hands of the employer and their qualified people. There are certain prescriptive requirements around specific types of equipment around dust management and dust collection that if an employer eventually chooses to go down the route of having or using any of these specific types of equipment, then those pieces of equipment would then have some prescriptive requirements allocated to them as well. Mike, I don't know if you have anything further to add to that.
No, I think you covered it well, Rodney.
Yeah, thanks, Rodney. And it's been my experience in that whole history of combustible dust for solid wood manufacturing that WorkSafe BC tends to try to work with operations and not against the operations. So when it comes to mitigating combustible dust hazards, it's a collective sort of process that people can go through with WorkSafe BC, and it's not necessarily a prescriptive process. The last question is, will guidelines provide any further exclusions or exemptions for the regulations, such as small or limited quantity of infrequent handling of dust?
So I'll take you behind the curtain for just a second. We played around with this concept, this idea of a small employer or a low risk employer. We kind of, in our working group work, we looked at that issue quite extensively. And to be quite honest, found it to be unmanageable as a means to try and determine what are the characteristics of a low risk workplace versus a not low risk workplace, and found ourselves splitting a lot of hairs. So what we then turned our mind to was actually making the regulations scalable, so that if your individual experience or exposure to combustible dust is very limited, or infrequently handling it, that's where the degree of sophistication of your risk assessment and your combustible dust program comes into play. It only needs to be as sophisticated as the level of risk that it is meant to cover. So in those very small workplaces with very limited exposure to combustible dust, the risk assessment it can be done relatively simply. And the program itself might be very short, corresponding to the level of hazard and risk at that particular workplace. So we tried to deal with it through that scalability provision, containing that within the performance-based regulation, and acknowledging that not every risk assessment is going to look the same, and neither is every combustible dust management program going to look the same.
And that question touches on what was probably our biggest, or at least one of our biggest challenges with developing this regulation that has to apply across the board to varying industries, employers, and commodities of dust.
Thanks. And I think that wraps up the questions, and further to the small or limited businesses. I think that's where I think the qualified person comes in that can help them design what's appropriate for their size of business too. So I think there's some parts of the regulation that helps out, I think, all levels or scaled for combustible dust. Now
And
that going
if I could just
forward-
add to that, Bill, like the regulation doesn't specifically require you hire a consultant or an engineer. If
Yeah.
you have the expertise, then it can be done in-house, maybe supplemented by some additional research and reading, but it's proportional to the level of risk that's presented at that workplace.
That's right.
And,
So
and
going
that,
forward,
as I
if
said,
any-
Bill, I'll send you that web page there for you to distribute as well, because that has all the information about the upcoming public hearing, including the link to the actual draft provisions.
So if anybody else has additional questions, they can email them to Tammy. Her information was included in the chat at the beginning of the presentation. We will be sending out any resources that we have to everybody that registered for the webinar, and they can send in, they can use that email for, sending in some other additional information. So I'd like to thank everybody for participating in the webinar. I'd like to thank Mike and Rodney for the great job they did in explaining some of what's going on with combustible dust and sort of next steps that are happening probably fairly soon. But we will also make sure that everybody gets a copy of the May 14th public hearing information. So thank you, everybody, and hopefully you'll look for us on the next episode that we'll have for different voices that'll come up probably in June.
Thanks,
Okay.
everyone.
Thank you,
Bye.
everyone. Thank you, Bill.